Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hello everybody, how you doing? Today we have news in the world of Brendan. The first Amicus Brief has been filed. And this one's in favor of Brendan. It's from the Juvenile Law Center. Very interesting, obviously. Who knows their stuff about juveniles and what they go through in the criminal justice process and stuff like that is who's gonna know better than them, because they've been studying it. They're at the head of that area of expertise, essentially. So they filed their brief, and mainly what it really does is it just goes through stating that the Supreme Court has clearly defined these principles and these guidelines for the courts to follow, and they're essentially coming right out and saying that the Wisconsin Court of Appeals failed to apply those standards and those practices, and that therefore is basically just ignoring the Supreme Court and what it's previously ordered in cases with juveniles. And when it really comes down to it, the main things that they're going on about here and trying to make it very clear is that, number one, the appeals court did not take into account age. Really, I mean, it didn't take into account age. It did mention age in its like conclusion, like of its summary of its argument, but it did not include Brendan Dassey's age when it was discussing the voluntariness of the confession in the decision. Interesting. Why would they not be mentioning his age there, where it's clearly supposed to be a huge factor as determined by the Supreme Court, right? So what the Juvenile Law Center is pointing out is that they mention Dassey's age, but they mention it over in the summary of their argument, not in the summary of the voluntariness of the confession. So I think that's pretty significant, because we know that the Supreme Court has deemed that juveniles require special care. And that they cannot be treated the same way as an adult, because they will respond differently. They don't have the sophistication or the experience in the world like an adult would to help them through this difficult situation that it is to be interrogated by police. So anyways, it's basically it's basically saying that, that the Wisconsin Court of Appeals in that sense has failed to take into account Brendan Dassey's age. And then it goes on to say further that not only did they not take into account Brendan Dassey's age, but they essentially didn't take into account his particular circumstances, his particular personality traits that, in Brendan's case, make him highly suggestible and makes him highly open to being coerced, and that's a special circumstance with Brendan that is obvious. And so when it's talking about the fact that when it mentions age, it mentions it in the summary of the argument and not in the area where it goes over the voluntariness of the confession, it's also making the argument that because it's not considering age, it's also not considering the special circumstances of Brendan Dassey, and that therefore the appeals court decision is basically like a huge departure from what the Supreme Court has deemed is necessary when it comes to the voluntariness of juvenile confessions. And so that's what this paper is mainly hammering home. It goes through a lot of different case law and stuff. So I went ahead and cherry picked a few of the best bits out here for everybody, and we'll go through them real quick. Interest of the Amici. That basically means why the Juvenile Law Center is interested and is therefore able to enter a brief. Amici Juvenile Law Center et al. work on juvenile justice, criminal justice, and children's rights. Amici have a unique perspective on the interplay between the constitutional rights and the developmental psychology of children involved in the juvenile and the criminal justice systems. The court has repeatedly made clear that the legal reasoning that fails to consider age can lead to fallacious reasoning. More specifically, the court established that confession cases turn on the youth of the accused, and that the adolescents are particularly susceptible to pressure during police interrogations. Nonetheless, the Wisconsin Court of Appeals failed to take age into account when determining the constitutionality of Brendan Dassey's confession. Amici share a deep concern that permitting courts to conduct the analysis set forth by the Wisconsin Court of Appeals would leave scores of children subject to coercive interrogations, heighten the likelihood of false confessions, and undermine the truth-seeking function that properly performed interrogations serve. According to the court, a 14-year-old boy, no matter how sophisticated, is unlikely to have any conception of what will confront him when he is made accessible only to the police. That the confession came tumbling out as soon as he was arrested was irrelevant because the youth cannot be compared with an adult in full possession of his senses and knowledgeable of the consequences of his admissions. To disregard this reality would be in callous disregard of this boy's constitutional rights. The Gallegos court adopted the reasoning of Haley v. Ohio, in which a plurality of this court held that the youth of the suspect was the crucial factor, noting that the age 15 is a tender and difficult age, marked by the great instability which the crisis of adolescence produces. The Haley plurality concluded that adolescents cannot be judged by the more exacting standards of maturity used for adults. So there was a couple of instances that the Amici was pointing out, the Amici being the Juvenile Law Center, where past decisions by the court, talking about Gallegos, and when he was the 14-year-old, and then moved on to talking about Haley, who was a 15-year-old, right? So Brendan being 16 and being challenged, I guess, in terms of his intellectual capacity, I mean, he was in mainly main track classes, of course, but he was getting some assistance, and you can tell. I mean, it's been proven. I mean, you got the psychologist that came in and evaluated Brendan, who said who basically determined he's more suggestible than 95% of the population. I mean, that's a staggering number of people, the 95%. So, I mean, it's all there. The proof is there. It was just never considered. And that's what this paper is really saying, and I agree, because how could it have been considered? And when you look at the appeal court's decision and you see that it's not mentioning the special circumstances of Brendan or the age of Brendan in its evaluation of the confession, on the voluntariness of the confession and all that, it doesn't mention those things at all, when it should. It's been clearly determined by the Supreme Court that those are supposed to be huge factors when it comes to a juvenile, but it's not there. But it's over in the arguments, in their summary of their argument. Then we've got Brendan's age and that he's mostly in main track classes or whatever, right? So yeah, I mean, this paper I think is really hitting the nail right on the head in terms of the appeals court flying in the face of Supreme Court precedent. So we got the next one coming up here now, so let's move on to it. Contrary to decades of clear guidance from this court, the Wisconsin Court of Appeals conducted no meaningful analysis of Brendan Dassey's age or developmental characteristics when assessing the constitutionality of his interrogation. The court failed to even mention Brendan's age in its voluntariness analysis, gave no meaningful consideration to any of his individual characteristics, and analyzed coercion using an adult framework contradicted by both the developmental research and this court's precedent. Indeed, when analyzed under the correct framework, the circumstances relied upon by the court actually support the conclusion that Brendan Dassey's confession was coerced. The Wisconsin Court of Appeals' conclusion to the contrary is therefore an unreasonable application of Supreme Court precedent. And although it is true that Brendan received Miranda warnings, that fact does not suggest that his confession was voluntary if, due to his age and cognitive limitations, he had limited capacity to understand the warnings given to him, the nature of his Fifth Amendment rights, and the consequences of waiving those rights. Rejecting the argument that a juvenile confession was voluntary because of the young person had been advised of his right to counsel. When these facts are properly considered in accordance with this court's precedent and combined with the abundant additional evidence of coercion, such as the inconsistencies in the confession, assurances of leniency, and leading questioning, the conclusion that Brendan's confession was coerced is inescapable. The Wisconsin Court of Appeals' conclusion to the contrary is based on an analysis that ignores Brendan's age and individual characteristics, and thus amounts to an unreasonable application of this court's precedent. So, as I said, they're really just hammering home that the Wisconsin Court of Appeals really did not give the special care and look into the special circumstances when it came to Brendan. All right, so there we have it. The first amicus brief, Amicus Brief, filed for Brendan's case with the Supreme Court. This one obviously was in favor of him, but there are likely to be others. There's likely going to be many others, and some of those are not actually going to be in Brendan's favor. They're going to be filed probably, for instance, by other states, basically DOJ departments from other states, and obviously from Wisconsin, I would think, or from agencies in Wisconsin that have an interest in all this injustice with Brendan. But anyway, so that's about it. Obviously, as they come out, I'm obviously going to be reading them, and I'll go ahead and do another similar video like you see here. If you haven't already, please hit subscribe, and we'll see you.